Wait, yep. Okay. Go.
Will you hand me my screen box?
Now go. Freak.
All right, so the next one then is St. Anthony Gardens versus Darlisha Overton.
Your Honor, Richard Schuster appearing for, may I come up here or it's just?
You can come to the lectern.
Richard Schuster appearing for St. Anthony Gardens, and I have a witness today, Mr. Dubby Pacol, who is on Zoom.
All right, do I have Miss Darlisha Overton? All right, so this time I know the defendant not present. And that's going to be at 1:17 p.m. Just let the record reflect that the court passed this last time because the defendant was present and sworn. And there were some questions about previous payments. Like she had paid $1,400 November by end of the month and returned in January. She said nobody ever told her to come pick up the check, money order before. She called them in January. And then I wanted to see what was the status of that payment. It was never told that they never posted it to her account by the time, and I'm not sure what that, but those are some of my notes. And then with Mr. Schuster, you and your client was present last time.
That's correct.
And I'll take some additional testimony today that the statements were, the outstanding balance in September, that you're still willing to do a standard agreement. But again, the client at that time, I noted did not have knowledge about any prior payment, attempted return service, but on-site property manager may have.
And he is on Zoom, Judge.
And then, and I just have some other notes. So let's just see where we're at on the testimony today. Mr. Perkall, if you'll go ahead and go off. There you go. Raise your right hand. Yeah, there you go. Do you swear or affirm the testimony provided to be the truth, the whole truth, and nothing but the truth, so help you?
I do affirm, yes.
All right, and at this time, I'm just going to turn you over to your attorney, Mr. Schuster, for some questioning.
Please state your name.
My name is Dove Percal.
And Mr. Pacol, are you the on-site property manager for St. Anthony Gardens LLC Apartments?
Yep.
And in the course of, well, has St. Anthony leased a unit to a Darlisha Overton?
Yes.
Folks, excuse me, Miss Overton
just joined Zoom. Thank you, everyone. So let me just catch her up real quick. All right, Ms. Overton.
Yes.
All right, this is on for the hearing today. Again, this is where I noted that you stated that you tried to make a payment. They returned the payment to you. I have a witness on from St. Anthony's Gardens who is just beginning his testimony. So, who's just beginning their testimony, and it's going to be related to the allegations of failure to pay rent. Before we get into that, I just want to make sure, is there any opportunity, or has there been any, are you still willing at all to extend the standard agreement before we get into testimony?
We are willing to do that. Yes, Your Honor.
All right. Ms. Overton.
Yes.
All right. So before we get into the full hearing where I would continue to take the testimony to the allegations of failure to pay rent, are you trying to pay everything you owe and stay here? Are you trying
Well, I was.
I'm
not going to have six. Go ahead.
Okay, just let me finish real quick and I'll give you a full opportunity to respond, ma'am. Because again, at this time, what a standard agreement entails would be to pass the case 1 week for all payment in full, including any late fees by certified funds. Doesn't include March rent because we're in March, or to completely vacate, move out from the property, take all your belongings and turn in the keys. If you pay or vacate, it does give you a dismissal with no eviction judgment on your record. It is a negotiated settlement. You need to understand that at this time, you will be waiving all your rights to assert defenses, your right to trial, and your right to appeal. In exchange, the case would be dismissed. The landlord would waive their right to go forth with the hearing today, which could render them, which could be, and I don't know, in their favor for an eviction judgment, which would give you 7 days to vacate. Just so what we can do today is continue forth with the hearing. And I'll hear you out. I'll hear any of your defenses. I'll hear their case. If I do find for them, it's an eviction judgment, 7 days. If I find in your favor, it is dismissed. With, of course, any opportunity for them to refile with proper manner. The other option is for you to take the standard agreement today. So just letting you know that before we start the full hearing, that option is still on the table. How would you like to proceed?
Well, I mean, I still feel like I wasn't given because they did not tell me that they weren't going to post my rent. I had no idea about the
Okay.
fact that they were going to even evict me.
All right. So I hear you just want to go forth with your hearing today.
Yes.
Okay. All right. Go ahead.
Mr. Patel.
So just listen to the testimony. The first witness on is from St. Anthony Gardens. Okay.
Okay.
Thank you, ma'am.
So, Mr. Patel, under the lease was Ms. Overton to pay rent in the sum of $1,350 per month.
Yes.
And St. Anthony Gardens filed a petition in December of 2025 stating that as of December 7, 2025, the amount back rent and late fees owed was the sum of $2,921.60. Does that sound correct?
That's correct. Yeah.
Mm.
Now, Ms. Overton states that she paid a sum of money, I believe, after the petition was filed. Before you came today, did you review the records from St. Anthony Gardens concerning the account of Ms. Overton?
Yes.
And do your records show any type of payment after December 7, 2025?
Does not. No.
December 7 or 17?
December 7, 2025. Thank you.
December 7th or 17th?
Well, December 17th.
We do not have any.
I'm sorry, what did you say?
We do not have any from that date. No.
100%.
Okay, and if St. Anthony Gardens had received any type of rent payment, would it have been recorded?
We would have sent an email. Saying to come pick it up.
An email saying to pick it up, or an email saying it was recorded, if you had recorded it?
Well, if it was posted, that would be able to be seen on the tenant's ledger. It wouldn't necessarily alert them, but they would be able to see it in their
Right.
account.
Okay, did you send her notice to vacate on or about November 10, 2025?
Yes.
Okay, and obviously Miss Overton is still living at the apartment?
Yeah.
That's all the questions I have here.
All right. Ms. Overton, do you have questions of Mr. Percal at this time? It's
I
your
don't have
time.
any questions. I'm just saying, I never stated that I made any payments for the month of December. I stated that my November.
Do you want to ask any questions? So you don't have any questions of like, do you know if this on-site manager, did you give any payments? Who you gave payments to?
Who is it?
Do you know who you gave payments to?
Yes, her name was Missy.
So, okay. So do you want to ask Mr. Percal if he knows about any payments you made to Missy?
Yes. So was there any knowledge of the money orders that was given to her that was never posted?
Missy does not recall any of it, receiving any payments and then calling you to take it back. We don't have any record. I don't remember calling you, and she doesn't either.
So
remember.
she doesn't remember me coming to the office and her giving me the money orders back.
Correct.
Oh, okay.
That's crazy, but okay.
No.
No.
How does she like okay.
All right. So if you don't have any other questions, I will still allow you to make a statement. I just want to make sure you didn't have any other questions, Ms. Percal. I mean, not Ms. Percal, Ms. Overton, you have any more questions?
Oh no, I don't have any questions. Again,
Okay.
I was just stating
Okay,
that.
so let me go ahead and place you under oath, Ms. Overton. If you raise your right hand, do you swear or affirm the testimony provided to be the truth, the whole truth, and nothing but the truth, so help you?
Yes, I swear.
Okay. All right. And so let me ask some questions at this time.
Okay.
You said, and again, that's why I think it's important that you were present. You're not present, So you said that you had paid by money order, correct?
Yes.
What date, what date was on the money order?
The date on the money order was for November's rent.
Where is the money order?
I don't have it anymore. The money order has already cashed in.
By who? Not
The
by
one
the,
who No, it was cashed in by who gave it to me. I got it from the post office.
and you don't have any of your proof today to give to the court to look at.
I mean, other than I might have a receipt from when I first purchased the money order, but my thing is, I thought that they kept documents of every payment as well.
No, ma'am, when you challenge a case, is you still need to meet certain burdens of proof. Okay? And when money orders are show that you attempted to do something, you got on this date, and I still need that type of proof. That
Okay, so ma'am, I don't have the proof, so it's fine. So where do we go from here? Like I don't have the proof, and that's just what it is. I'm willing to accept whatever they go with at this point.
I mean, we can still extend the standard agreement, and I don't know if the
Right.
company is willing to
Like
work.
I really have nothing else to. I don't have the proof. I
well,
don't.
that's unfortunate. I'm sorry.
It
I mean,
is. It's unfortunate. I agree, but I don't. I just don't have it. But I know what I did. I know that I gave it to them, and I know that they gave it back to me, and they know that.
okay. When did you first give it to them?
The end of November. Oh, let me pull up my calendar. It was definitely the end of November.
So you gave it in the end of November. And
Yes,
then
around November the 24th.
do you know how much it was for?
Yes, it was for $1,400.
And you didn't, and so with money orders, you don't have the money order, but do you have the bottom portion anymore?
That would be the portion I would need, ma'am, and I don't have that. If anything, I can go to the post office and see if they can give me a receipt or something.
Yeah, but today is the day for the hearing, so you need
Okay,
it.
yeah, and as
Let
I
me.
stated, I don't have it, so.
Okay. Okay. So then you allege that you gave it to somebody, and then did you ever, they talked about, the witness talked about it being on a ledger. Did you
Mhm.
ever see it posted on your account?
No, I did. I never seen it posted on the account, no. Because the thing is, in the past, I've never had to check. My rent has always been posted. I never had a problem.
Okay, and do you notice that it's normally checked by being like you getting this text notification or something saying, yes, it's posted?
I never get a payment saying, yes, it's been posted. If anything, I get one that says, thank you for your payment, but that's only if I pay online.
And then it's your testimony that when did someone call you, or how did you become aware that they didn't accept this $1,400?
Because I got the eviction in the mail. Again, I didn't even know that they were filing an eviction or nothing. I got the eviction in the mail. That's when I called them because they told me I owe for November and December. So when I called them, I said, no, I brought a money order in there for November. And then that's when they told me I can come get the money order because they were proceeding with the eviction. So that's what I did.
Okay. And that would have been at least like sometime in mid-December?
Yes. Well, actually, I picked up the money order the first week of January.
But when did they tell you to come get it?
They told me the day prior. I just didn't go because the office was closed. So I went the next day. I spoke with them.
So in January?
In January, yes. The first week of January.
So my other concern though still is, Mr. McCall, is that you're telling me there's nobody in that office that has any knowledge of this conversation besides someone who wouldn't have been the person in the office. That's your own
Correct.
witness?
And when I went
No,
into
one moment, please. One moment.
okay.
Cause it's kind of like this is actually a he said, she said. I don't know if I should give any more weight to the testimony of Mr. Percal and I should give to Miss Overton.
May I ask Mr. Percal a question?
Sure.
So before you came here today, did you look at your records? And if so, when did you last receive a payment from Ms. Overton?
The last payment we received, I believe, was a money order on 10/30/2025. That was the last payment we've received.
And you know how much that was for?
There was a $1,000 money order and a $580 money order.
I see.
And what were those payments for? What months?
October.
And is it my understanding, and you may or may not know this, that a money order cannot be for over $1,000?
I'm not sure.
Can I speak, ma'am, real quick?
Permission to speak. Go ahead, Ms. Overton.
So the guy who's talking on here with me, who is he? Is he the manager?
He's a manager. Yeah, I'm sorry.
Okay, so
You missed his introduction.
okay, so
So do you have you have a phone record when you talk to someone at the office? You said it was a Missy
I'm pretty sure I do. Okay, so ma'am, when I spoke on the phone about the money order, it was a guy, and it had to be him because I don't know who else works in the office that's a guy.
It only would have been me, and I have no recollection.
Exactly. And so you are the one who I was talking to about the money order. And when I went in to pick it up, it was Missy who gave it to me. But when I spoke on the phone, and if I got to go pull phone records, I would do that. Because when I spoke on the phone, I spoke to a guy that I've never even seen in the office before. But
Okay.
I was told he was the manager.
Would it be so? Is there any other gentleman who works there who would have could have been possible taking Miss Overton's phone call?
No, it only would have been me.
Because the concern continues to remain that I understand why she's not taking standard. She would waive her right to assert defenses, and any payment that they kept for that long and did not return to her is grounds for a dismissal.
Well, he's saying they never got the pay.
I know, but he doesn't. I mean, but who did she talk to? And they just keep saying they don't recall.
Well, it's her word versus my word.
It is.
It is. So why not say you spoke with me when you spoke with me?
Miss Overton, let me do that.
I'm sorry, ma'am. I'm sorry. Okay.
So I do have concerns that both of you are lacking in evidence. The only problem, Miss Overton, is that since that today's the day for the hearing, and you failed to present proof outside of your testimony. But I'm not saying so if I put Miss Overton and Miss Perkow on the same grounds, it really is a big concern for the court. That Mr. Perkow and them have no evidence that they accepted someone's payment and then sent it back, as a company should have. She, of course, has failed to. She could go, and I'm more inclined to pass this one more time to give her an opportunity to go to. I mean, again. You might not get anywhere, but somebody here needs to have proof.
Yeah, that's fine. Like I said, I can pull
Overton. Would you let me have a second?
Okay.
The concern for the court is that there's no proof to refute what she's saying either. But what we do have is proof of failure to pay from now. But again, her defense is that she gave a payment, believed it was accepted. Your client accepted it for potentially held on for it too long, and it should have been accepted as a waiver, and then they need a refile.
No, but she says he never got it.
That's all he says, but he has no proof that he never got it, and there's no ledger saying. I understand, but I still think that puts them on the same grounds. I give him just as much weight as I give Miss Overton.
Thank you.
They're the same. It's a he said, she said, but I do find it. I don't often get people coming and saying we gave money order, and then it wasn't. That was some question. So last time when the individual was here, that I think she did the same. She actually said the same thing. I have no knowledge about when payment was attempted and returned. The on-site property manager may. Then they said payment in November was supposed to be November 19th, as shown in her system, but no payment noted in her account. So Ms. Overton.
Yes.
You understand that you are still in a hard position to where you are the one who still needs to present proof that you had a money order that you gave to them that they rejected. If you cannot bring that proof in, it will be difficult for you still as well to win.
Okay. Okay, so I'm going to try to get that, and in the meantime, I'm going to have the phone conversation as well.
No, I doubt they're probably going to talk to you. Talk with who? Phone conversation with who?
The phone conversation that I had with the property manager.
Oh, you
at
mean to show
St.
that
Anthony.
you made a phone call?
Yes, and that I spoke with him and what I was told, the whole conversation.
How are you going to have? What do you mean have the conversation? Did you record
There's
it?
got to be some way. I'm gonna figure it out. But yeah. Well,
All
so
you could do is probably have a phone record saying you made a phone call out and where it was made to, and maybe how long the phone call was if you were to get that, because
okay.
it's not going to be recorded. If it is, you
Okay.
should be concerned. Okay. No, seriously. I'm gonna pass this one more time because I do not like that there's not enough testimony on both sides for me to feel good about making a ruling. So let's do March 16th at 1:00. Miss Overton, it's important you be in person because you'll need to show your proof.
Okay.
All right, so I'm gonna continue this one last time. And then it's always better again if your clients want to bring in their lack of proof by at least showing a ledger. I haven't seen anything.
Right.
You know. One last time for all parties to present proof. Now, at the beginning of this hearing, Ms. Overton, they still stated they are willing to take all your rent in full for the dismissal. I would advise you if that is an option you would like to take, that you want to stay there, that you entertain exactly how much it is owing due. Get that in certified funds, see if that only then will they be ready to accept it. It would have to include March rent, and then the case could be ripe for dismissal because you've paid everything you owe. Because regardless of how it turns out, you need to pay your rent before they would refile, and you could be subjected to a legal eviction because you have failed to pay rent. You understand, Ms. Overton?
Okay.
I mean, because there won't be a, you know that rent is continuing to be accrued. And you might be able to negotiate what that may be. And again, I think last time I usually tell people to reach out to legal aid and have discussions with them because they're the attorneys over there are used to trying to work out things with with Mr. Schuster and his clients and all the other plaintiffs' attorneys who work in here. So I'm not sure if you even took that option before, but all right. So we're going to go to March 16th at 1 p.m. And again, imperative, I've told you, Ms. Overton, to appear in person, okay?
Okay.
Yes. Okay. All right, that's all for today.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot break myself from.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Mr. We're going to start bringing people in person. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
For too long, I gotta go. I grab my bag and hit the dash. I'm the one that needs the drink.